consequences. The most difficult part of a lawyer's work is always to establish the true facts, not the application of the legal rules to these facts. Unfortunately, a German lawyer does not learn this at law school, but his Anglo-American counterparts do get the necessary training for this at their law schools. And probably for this reason, but also because of the much more pronounced independence of the Anglo-American judiciary, the Anglo-American law of evidence is much more effective in practice than the German one. A court of law can only decide a legal dispute correctly if it has previously determined the facts correctly, which is not possible without looking at all the evidence. And that's why the law of evidence is so important. On the basis of the facts summarized above, in particular those established with the help of the work of the German Corona Committee, the legal evaluation is actually simple. It is simple for all civilized legal systems, regardless of whether these legal systems are based on civil law, which follows the Roman law more closely, or whether they are based on Anglo-American common law, which is only loosely connected to Roman law. Let's first take a look at the unconstitutionality of the measures. A number of German law professors, including Professors Kingreen, Morswig, Jungblut, and Vosgerau, have stated either in written expert opinions or in interviews, in line with the serious doubts expressed by the former president of the Federal Constitutional Court with respect to the constitutionality of the Corona measures, that these measures, the Corona measures, are without a sufficient factual basis and also without a sufficient legal basis, and are therefore unconstitutional and must be repealed immediately. Very recently, a judge, Thorsten Schleif is his name, declared publicly that the German judiciary, just like the general public, has been so panic-stricken that it was no longer able to administer justice properly. He says that the courts of law, and I quote, have all too quickly waved through coercive measures which for millions of people all over Germany represent massive suspensions of their constitutional rights. He points out that German citizens, again I quote, are currently experiencing the most serious encroachment on their constitutional rights since the founding of the Federal Republic of Germany in 1949. In order to contain the corona pandemic, federal and state governments have intervened, he says, massively and in part threatening the very existence of the country, as it is guaranteed by the constitutional rights of the people. What about fraud, intentional infliction of damage, and crimes against humanity? Based on the rules of criminal law, asserting false facts concerning the PCR tests or intentional misrepresentation, as it was committed by Messrs. Drosten and Wheeler as well as the WHO, can only be assessed as fraud. Based on the rules of civil tort law, this translates into intentional infliction of damage. The German professor of civil law, Martin Schwab, supports this finding in public interviews. In a comprehensive legal opinion of around 180 pages, he has familiarized himself with the subject matter like no other legal scholar has done thus far, and in particular has provided a detailed account of the complete failure of the mainstream media to report on the true facts of this so-called pandemic. Messrs. Drosten, Wheeler, and Tedros of the WHO all knew, based on their own expertise or the expertise of their institutions, that the PCR tests cannot provide any information about infections, but asserted over and over again to the general public that they can, with their counterparts all over the world repeating this. And they all knew and accepted that on the basis of their recommendations, the governments of the world would decide on lockdowns, the rules for social distancing, and mandatory wearing of masks, the latter representing a very serious health hazard, as more and more independent studies and expert statements show. Under the rules of civil tort law, all those who have been harmed by these PCR test-induced lockdowns are entitled to receive full compensation for their losses. In particular, there is a duty to compensate, that is, a duty to pay damages for the loss of profits suffered by companies and self-employed persons as a result of the lockdown and other measures. In the meantime, however, the anti-corona measures have caused and continue to cause such devastating damage to the world's population's health and economy that the crimes committed by Messrs. Drozd, Wheeler, and the WHO must be legally qualified as actual crimes against humanity, as defined in Section 7 of the International Criminal Code. How can we do something? What can we do? Well, the class action is the best route to compensatory damages and to political consequences. The so-called class action lawsuit is based on English law and exists today in the USA and in Canada. It enables a court of law to allow a complaint for damages to be tried as a class action lawsuit at the request of a plaintiff if 1. As a result of a damage-inducing event, 2. A large number of people suffer the same type of damage. Phrased differently, a judge can allow a class action lawsuit to go forward if common questions of law and fact make up the vital component of the lawsuit. Here, the common questions of law and fact revolve around the worldwide PCR test-based lockdowns and its consequences. Just like the VW diesel passenger cars were functioning products, but they were defective due to a so-called defeat device because they didn't comply with the emissions standards, so too the PCR tests, which are perfectly good products in other settings, are defective products when it comes to the diagnosis of infections. Now, if an American or a Canadian company or an American or Canadian individual decides to sue these persons in the United States or Canada for damages, then the court called upon to resolve this dispute may, upon request, allow this complaint to be tried as a class action lawsuit. If this happens, all affected parties worldwide will be informed about this through publications in the mainstream media and will thus have the opportunity to join this class action within a certain period of time to be determined by the court. It should be emphasized that nobody must join the class action, but every injured party can join the class. The advantage of the class action is that only one trial is needed, namely to try the complaint of a representative plaintiff who is affected in a manner typical of everyone else in the class. This is firstly cheaper and secondly faster than hundreds of thousands or more individual lawsuits. And thirdly, it imposes less of a burden on the courts. Fourthly, as a rule, it allows a much more precise examination of the accusations than would be possible in the context of hundreds of thousands or, more likely in this corona setting, even millions of individual lawsuits. In particular, the well-established and proven Anglo-American law of evidence, with its pre-trial discovery, is applicable. This requires that all evidence relevant for the determination of the lawsuit is put on the table. In contrast to the typical situation in German lawsuits with structural imbalance, that is, lawsuits involving, on the one hand, a consumer, and on the other hand, a powerful corporation, the withholding or even destruction of evidence is not without consequence. Rather, the party withholding or even destroying evidence loses the case under these evidence rules. Here in Germany, a group of tort lawyers have banded together to help their clients with the recovery of damages. They have provided all relevant information and forms for German plaintiffs to both estimate how much damage they have suffered and join the group or class of plaintiffs who will later join the class action when it goes forward either in Canada or the US. Initially, this group of lawyers had considered to also collect and manage the claims for damages of other non-German plaintiffs, but this proved to be unmanageable. However, through an international lawyers network, which is growing larger by the day, the German group of attorneys provides to all of their colleagues in all other countries, free of charge, all relevant information, including expert opinions and testimonies of experts showing that the PCR tests cannot detect infections. And they also provide them with all relevant information as to how they can prepare and bundle the claims for damages of their clients so that they too can assert their clients' claims for damages either in their home country's courts of law or within the framework of the class action as explained above. These scandalous corona facts, gathered mostly by the Corona Committee and summarized above, are the very same facts that will soon be proven to be true either in one court of law or in many courts of law all over the world. These are the facts that will pull the masks of the faces of all those responsible for these crimes. To the politicians who believe those corrupt people, these facts are hereby offered as a lifeline that can help you readjust your course of action and start the long overdue public scientific discussion and not go down with those charlatans and criminals. Thank you.